little bit of discussion in the previous chapter about these sources such as common law, equity, and statute. We'll discuss upon that, and importantly, we will discuss about the laws related to the precedent, what it is and how it formulates the UK law structure. Then we will study about the legislation, that is the statute, how is it formed in the parliament. We'll study the structure of the parliament and the process of formation of laws in the parliament. And then important area is the statutory interpretation. Sometimes law is formulated in a way, if you remember in the previous chapter, in the previous session, we discussed that judiciary, it is the role of judiciary is to interpret the laws. They cannot make the laws, but sometimes the language of the law is such that it creates a kind of a confusion. So we will study 4 different rules of statutory interpretation, and in the end we will have a brief session of human rights laws. Okay. Number one, the first source of law for UK is the case law. Now, if you remember in the previous session, I told you that even in earlier days, whenever there was a tribe or a settlement, people used to have certain rules and regulations to or norms or the customs that were there. In the UK, it was the same thing. So when later on the society started to develop and the court structure started to develop, judges would use those norms and customs to make their decisions. And when they made those decisions became part of the law. That is called the case law. The judges made law is called the case law. It does not mean that the judges actually made the law. It is just that they implemented those customs and norms, and now it has been documented. Unless the parliament thinks that a certain case law is now irrelevant or needs to be changed, the law will continue. However, whenever the parliament thinks that a certain law, case law based on case law needs to be changed, the parliament is sovereign. It has the authority to change that law. So that is how it works. And part of the case law was the precedent. What is a precedent? Precedent is a previous court's decision. You see, for example, I am a judge and a certain case is in front of me. And there are definitely some facts of the case. For example, it is a case of stealing some object. Say it is a case of stealing jewelry. Now, I will study the case in front of me. Both the lawyers will present their case arguments in front of me. Evidence is in front of me, just like we discussed in the previous class. And I will now see whether there is a case in the history in which something was stolen. Now, this is called the material fact. Something was stolen. It does not mean that it must be some jewelry. Maybe it was a loaf of bread. Maybe it was a horse, whatever. It was stolen worth same money. Now, I as a judge am bound to implement that same decision that was in the previous case. That is called the precedent. So let's read it again. Precedent is a previous court's decision which another court is bound to follow by deciding a subsequent case in the same way. So if the material facts of that case, earlier case, and this case right now in front of me are the same, I as a judge am bound to apply the same. If I am bound to apply the same decision and same sentencing, that means that that is a precedent. We'll study about its different types as well. Now, now, where does this precedent come from? It is from the different reports, adequate and reliable reports of previous decisions. Judges can find these out on themselves by their through their clerks and office. Sometimes the lawyers also present the previous cases as a precedent. Then there are certain rules for extracting the legal principle and the classification. Some precedents are binding, some are persuasive. Now, in order to understand the binding precedent, you need to recall the hierarchy of the structure. Let me first take you to that, and then I'll come to this. This is the diagram. Here you see magistrate court, county court, and crown court. If you remember, we said that these are the lower courts. then the High Court, in which we have now King's Bench Division, and then the Court of Appeals, and then Supreme Court. Now, if you look carefully, this is about the precedents. Magistrate court is bound by all the higher court than itself, but its own decision is not binding on anyone because it is the lowest one. Meaning that if a magistrate courts take a decision, later magistrate court can take a different route, can take a different decision. It is not binding on itself even. Similarly, the county court, all the other higher courts decision are, for example, meaning if high court has taken a decision and now a similar case is in front of the county court judge is bound to apply the high court's decision as it is, if the material facts of the case are the same. Similar is the crown court. Now, if you go further, high court, judge sitting alone, divisional court, court of appeal, Supreme Court, the higher court decision. So in order for you to understand in the and attempt rightly in the paper, what you need to do is to understand and remember the hierarchy of the court. So if it is it asks you whose decision is crown court bound to follow, means that it is bound by all the higher courts. But if it says that whose decision is binding on if crown court's decision is binding on anybody, you will have to show the check it out the lower courts. This means that the Supreme Court's decisions are binding on every court under it, and the magistrate and county and lower crown court, they have to follow the decisions of the higher courts. This is how doctrine of judicial precedent works. Now, the two distinctions: binding precedent. Just a minute, please. I'm on babysitting duty today for my daughter. Okay. So, binding precedent and the persuasive precedent. Now, binding precedent, you have understood that the lower court is bound to apply the same decisions of the higher court, not high court, higher court, all the higher courts, if the material facts of the case are the same. But sometimes it happens that a case is in front of a judge and there is no binding precedent for that particular case. For example, a judge in the UK has a case in front of himself, but there is no such precedent in the UK history. But a similar case has been dealt in the US. Now, because US is a different country, even if it is a US Supreme Court, its decision is not binding on the UK Supreme Court or UK courts. But they can take persuasion from that. They can take hints from that. They can take an idea from that. Then it is up to the UK court whether they apply the same decision or they do not. So that is called a persuasive precedent. They are not bound by it. Similarly, if a high court decision is there and in certain cases Supreme Court has to decide, Supreme Court is not bound by the high court decision. But if they take that into account, they consider it, that can be called as a persuasive precedent. Okay. Now, the Court of Appeals, or whenever you have to go for an appeal, the concept of appeal is that whenever in a court a decision is taken, if it is a civil case, we know that the decision will be liable or not liable between two parties. If it is a criminal case, it will be guilty or not guilty between prosecution and the defendant, and prosecution is the state. Now, if either of the parties in either of the settings is not happy with the decision of the court, they can appeal in the higher court. So they do not agree with the ruling or the sentencing, meaning the final decision. Suppose if it is a criminal case and judge says that it is to be a life sentence or 10-year sentence or whatever it is. So that party can go to the higher court and make an appeal over there. When a higher court is appeal is made in the court of appeal, suppose in the civil division or the criminal division, there are two possibilities, three rather. One is that the decision of the lower court is not changed, it is kept the same, then that is fine. Otherwise, there are two possibilities. One is called the reversing and other is called the overruling. Now let's see this. Reversing or overturning means when the decision is changed by the appellant or higher court because of the error in judgment by the lower court. A possible misinterpretation of the law means they reverse the decision. If it was guilty, they convert it into not guilty. If it was liable, they convert it into not liable, or the other way around. That is called reversing. The higher court says that the law is fine, nothing wrong with the law, but the lower court did not interpret the law properly. That's why we are changing the decision. The law stays. The main thing is that the law stays. Overruling a decision is different. Is the setting aside of a precedent by a court expressly deciding that such precedent should not no longer be controlling the law, meaning they change the law. They say that, for example, maybe the precedent that is there is because of a common law. And after that, suppose, let me give you an example. Like in the common law precedent is from 1999 and now it is 2025. The judge made a decision in the lower court based on the precedent from 1999. But along the way, in year 2022, the parliament had approved, enacted another act because of which this law was nullified, that was cancelled. Now, the higher court will say that because that law was nullified, that is no longer controlling the law, that precedent, and therefore the ruling is not correct. Or maybe law says that, okay, there was no precedent change, but now in 2025, the scenario has changed and some other similar law is there because of which we do not want 1999 precedent to be controlling the law. Now, in this case, sometimes the higher court will keep the judgment of the lower court but change the law for future. And sometimes they will say that the previous court decision is also changed as well as the precedent is also nullified. It can no longer be used. So this is the basic difference between reversing and overruling. Let me summarize. In reversing, the law stays, the ruling is reversed. In overruling, the ruling may be reversed, may not be reversed, but the law is no longer continued. It is cancelled out. Okay, a brief area of discussion, that is case management. Case management means how the cases will be heard in different types of courts. For example, just like we said that earlier, that sometimes the cases can start in the high court as well. It depends on the value of the case. What is the monetary value of the case? So there is small claims track, fast claims track, and multi-track. Small claims track is for those claims that are less than 10,000 pounds. There is an exception to it if there is a personal injury case. Now remember here this point, the word injury and personal injury. In law, whenever there is a damage to somebody's property, somebody's fame, somebody's health, body, property, anything, asset, that is called an injury, means a damage has been caused. But if it is actual bodily harm, then we say it's a personal injury. So you need to remember that injury does not mean a physical injury. If the law wants to tell you about the physical injury, it will use the word personal injury. Otherwise, injury means an injured party. Does not mean that it has been he or she has been physically harmed. It means that person has suffered some loss or detriment. So in personal injury cases, when suppose somebody hits somebody, The small claims track is limited to 1,000 pounds. After that, if it is a personal injury case, it goes to the fast track. Fast track claims are between 10,000 pounds and 25,000 pounds, and above that goes to the multi track system. So, for this, there's no further details required. You just need to remember this from the MCQ. And usually, this is a 1 mark MCQ from this area. That number one, what are the different types of tracks that you need to remember? Small, fast, and multi. There is no medium track. And what is the amount limitation on these? This gives you a general map idea. Just take a look. There's no specific need to memorize it. Just take a look of it. These are the different circuits or different areas in which the UK is divided according to the judicial system. Okay. Now, Parliament. The another important area. Now we have studied the case law as well as the precedent as a sources of law. Another important area is the Parliament. Now, this is a general description of the parliamentary structure, and then I'll show a video as well as the process of making law in the UK. Legislature or Parliament of the UK is made up of Crown, means the king now, and the two chambers of Parliament, and it is known as bicameral. Bicameral means there are two chambers. The two chambers are House of Commons and House of Lords. Member of House of Commons are also known as an MPs or member parliament. They are elected just like in the general election process, and they are elected for each constituency on the first past post basis. No need to further detail of that. And the House of Lords, it has about 790 members. Usually, it has never been the case that the paper asks about the numbers. That is not required usually. Historically, these were the people who were the lords of different areas in those, and who used to support the king and who used to form allegiance with the king, and they were under the king's law, but they used to rule their own areas as well. Then this is the basic parliament structure. Then there is regional and local governments as well. I'm sure it is there in any country, because the main government cannot go into each and every area. So under the MPs, they have their own constituencies, different areas, and under which there is a system of governance, for example, to construct the roads, to street lights and health facilities and things like that. So for that, there are regional and local governments. Northern Ireland, Wales, and Scotland has a regional national assembly elected by proportional representation, of whom state power government, central government has been devolved. Throughout the UK, locally elected local council, this is the main idea because we will study about the delegated legislation later on, have the power to make rules on matters such as building policy and public hygiene, and to raise local taxes to fund the local highway maintenance, etc. Status of judiciary is that judiciary is independent, appointed on professional merit. The Constitutional Reform Act imposed. Okay, fine. That is the basic structure of the UK. Now, uh, the basic concept for today would be how the laws are made in the UK and what are the different types of legislation or law. Legislation, whenever the word legislation is there, it means it is the parliament made law. Number one, parliament can make any law. That is the basic principle, that parliament can make any law. But cannot pass a law that it cannot repeal, meaning that every law that the parliament can make, later on it can change it. So even if they include something in a certain law, that this law can never be changed, and even if there are 100% votes of it on it, that will be void. That is automatically impossible. The parliament is sovereign. This means that they can change any law, and make any law. Courts cannot question the validity of an act of parliament unless it contravenes with European Union law. So, parliament is sovereign. They have to make all the laws unless and until there is a problem with the European Union law, and now even that is not required. It is now the human rights courts. We'll study about it later on. So UK, after Brexit, they were part of the European Union. Now they're out of it. So the European Union laws do not apply to them, but the international human resource laws do apply to them. Still, the judiciary cannot change the law. They have to recommend to the parliament to make the required changes. Now, when we say statutory legislation, there are two parts of it. Number one is the Act of Parliament, the process of passing laws in the Parliament. And second is the delegated legislation, when the Parliament gives its legislative powers to the local authorities, to the municipal committees, and for the local area management. That is called delegated legislation, or they use bylaws. We'll come to it later on. First, let us discuss the process of making law in the parliament. I'll show you a video on this, and then we can take it from there.
The UK parliamentary system can seem a little confusing from the outside. It's hard to know what's going on inside Parliament and what it means for your life. That's why we run a series called This Week in Parliament to show you exactly what bills are being discussed on the floor. We have loads of people ask us to go into more detail about how bills actually go through the House and explain how laws are passed in the UK. Before we go into the specifics of the bill, it's important to first understand just how the British Parliament works. Parliament is split into two houses, the House of Commons and the House of Lords. The House of Commons seats 650 members of Parliament, or MPs, people elected to represent areas of the UK known as constituencies. The House of Lords sits around 800 unelected members known as Lords. They're appointed by the Queen, usually at the advice of the Prime Minister, or the House of Lords Appointment Committee, established in 2000. The role of the Lords today is to hold the government to account and make sure that the laws being passed are effective and fit for purpose. They cannot veto legislation though, they can only delay it for 1 year. Historically, this wasn't always the case. In the past, if the House of Lords didn't like a piece of legislation that the House of Commons suggested, they could stop it completely. This changed due to the passing of the Parliament Acts in 1911 and 1949. These acts removed the veto power from the House of Lords, and instead allowed them to delay legislation for 2 years and then for 1 year, respectively. These steps majorly reduced the power of the House of Lords. In addition to this, the Salisbury Convention, which started in the 1940s, was and still is an agreement between the House of Lords and the House of Commons, which says that if a piece of legislation is in the government's manifesto, the House of Lords will not block it at the second or third reading. This again reduces the power of the House of Lords. So in the modern day, the House of Lords has a lot less power than it once did, and serves only really as a check to make sure that the pieces of legislation are fit for purpose. This isn't to say that their job isn't useful, just that they can't cause as big a problem for the government as they once could. Now we've explained a brief history of the relationship between the House of Commons and the House of Lords, it's time for the exciting bit: how the laws are passed. For the purposes of this video, we're going to look at bills starting in the House of Commons, introduced by the government, known as public bills. There are also what are known as private members' bills, which are introduced by MPs or Lords who are not government ministers, as well as private and hybrid bills. There's so much to discuss that we'll have to do that in another video. If you'd like us to cover these types of bills in a video, like this video and comment below to let us know. The first step towards legislation is often a green paper, which is usually vague and contains multiple policy options. These are consultation documents, introduced mainly to stimulate parliamentary discussion on the topic of legislation. Once it's been briefly discussed in Parliament, the government will usually begin consulting citizens and the public bodies which are most likely to be affected by the legislation. Once this process is finished, the government will then issue what's known as a white paper. This will be informed by the public consultation and contain more concrete policy proposals. They often include a draft bill to provide a basis for changes to be made before the bill is formally presented to Parliament. Finally, a bill is formally proposed and read. This is the first reading. There's no debate at this stage. The bill will usually just be read to the House of Commons. The next stage is the second reading. This is when the House of Commons has its first debate on the proposed bill. After the debate, MPs have a vote on whether the bill should continue. If it succeeds, then the bill goes on to the third stage, known as the committee stage. This is when one of the committees in Parliament takes a closer look at the proposed bill. The chairman of the committee can then decide which amendments to the bill are discussed and then voted on by the committee. After this is a chance for the whole House of Commons to suggest amendments. This is known as the report stage. Once the whole of the House has had the opportunity to suggest amendments, the bill goes on to its third reading. Usually there's little debate. At the end of this stage, the bill is voted on. If it succeeds, then it goes on to the House of Lords. At this point, the process is repeated in generally the same format in the House of Lords. Like in the House of Commons, the bill goes through a first reading, second reading, committee stage, report stage, and third reading in the House of Lords. If the House of Lords decides on any changes to the bill, then it's then sent back to the House of Commons to be debated and agreed to there. If during this stage the House of Commons makes any amendments, it's then sent back to the House of Lords to agree to. This continues until no more changes are made. This back and forth procedure is known as ping-pong. Once the ping-ponging has stopped, and both houses have agreed on the wording of the bill, it's sent to the Queen for royal assent. This is when the Queen signs off the bill and allows it to become law. It's a convention that the Queen always grants royal assent. The Parliament Acts, mentioned earlier, can be used if during parliamentary ping-pong, neither house can agree on the wording of the bill. The House of Commons, in these exceptional circumstances, pulls rank. So it's clear that both the House of Commons and House of Lords play a vital role in the lengthy process of creating laws in the UK. If you want to stay up to date with where bills are in this process and what MPs are debating in the House, you would enjoy our series this.
Okay. So that video would have given you a detailed idea of how the whole process works. To summarize it from the paper point of view, this is what you need to remember. Two houses, the bill can start from any house. If it starts, for example, from House of Commons, it will go from first reading to second reading to committee stage to report stage and third reading, and then it will pass on to the House of Lords. It will follow the same pattern in the House of Lords, and then if there are no other changes, it is sent to the king for royal assent. Royal assent means the king has to approve the law, and it is a convention that the king does not, because previously king had the legislative powers. It is just a ceremonial figure now. He must agree to the law that is being presented. Okay. With this, we'll take a short 5 minutes break, and then we will continue with the next topic, which is delegated legislation. You could please freshen up in the meanwhile. Okay, now, once the parliament has made the laws, it is for the whole country, and obviously it has a broad domain. Sometimes in the different parts of the country, the requirement of the law is a little bit different, a little bit varied. For example, you see a part of the country which is economically very sound. There are a lot of businesses over there, industrial estates over there. It is a rich part of the country and can pay more taxes. and the other area of the country may not be very much well off, and it is not economically sound, and it cannot pay a lot of taxes. So this means that the different areas, businesses of the same nature, of the same size, may have to pay different amount of taxes or other duties or other expenses differently. So for this, this is just an example. For this, because of the differing nature of requirements of law in different areas, the parliament gives powers to the local authorities, to the local bodies, to make laws under the umbrella of the main legislation and then implement those laws in their particular areas. That is called the delegated legislation. The main idea that you need to remember is that it is to save parliament's time. So the local area laws, if we want to get them made by the parliament, a lot of parliament time will be taken, and because of the varying nature of all the requirements, it parliament will not be able to make the laws related to the whole country. Rather, it will be mostly focusing on many different areas, and in a way its time will be wasted. So these powers are actually given to the local ministers, public bodies, local authorities. It is also known as the subordinate or delegated legislation. Okay, the parliament usually has a control over delegated legislation by keeping production of new delegated legislation under review. Some statutory instruments do not take effect until approved by affirmative resolution of the parliament. It does not debate on it in detail, just like making while making an act, but it considers it, reviews it, and then gives an affirmative vote on it. Otherwise, other statutory instrument must be laid before Parliament for 40 days before they can take effect. So that number you need to remember. Okay. It can be in different forms. Ministerial powers, powers of the ministers exercised by statutory instruments. These are the most common form. Local authorities, they have the power to make the bylaws for their particular area. Rules of the court may be the judiciary control or judiciary to control the court procedure. For example, just like we studied about the different tracks. Professional regulations concerning certain occupations such as law, such as ACCA, can be delegated to local authorities. Orders in the council. Council means the Privy Council. Previously, the history of Privy Council is that previously the king had a number of very close uh, members of his cabinet that were the closest to him, and they used to help in making different decisions, different laws, and they also used to uh, pass judgments in the courts of law as well. So previously, like you checked in the video, previously House of Lords and Supreme Court were the same. Now they have been split. So in olden days, the laws that were coming, the cases that were coming in appeals, they used to come up to the Privy Council as well. Later on, when we studying different areas such as contract law, I'll be showing you very varied videos, and in some videos you will see the role of the Privy Council as well, even though nowadays it is of not much of an importance. The next area that we need to focus upon is the statutory interpretation. And it is a bit lengthy, it has different sections in it. First of all, what does it mean? The word statute means the act of parliament. So when parliament makes a law, we have studied that it has a lot of background on it. And finally, they make one particular law and they print a book that is concerned with that law. For example, you have Companies Act. in your course that we will study. You have Partnership Act to an extent in your course that we will study. So Companies Act is a complete document, but it is not the whole. There are certain documents which are related to this act but are not included within this book. For example, the green paper, white paper, the earlier discussions, the debates that were conducted in the while making the law, these are not included in it. Sometimes what happens is that when the judge has to make a decision, obviously he has to refer to the act, if not common law or precedent. If it has to check the act and there is some wording in the act which is not clear or not certain, means it can have at least two different meanings. Then it is the judge's job to make an interpretation of that statute, and that is called statutory interpretation. This will happen only when the judges are not clear on, or the language of the law is not very clear. It has ambiguous meanings. Only then it will be implemented. So that needs to be very clear from the interpretation. So what is the need for interpretation? The meaning of statute may be unclear in different specific circumstances, because when the law was made, not every single possible scenario can be assumed by the parliament at that time. So they make a law, and sometimes it so happens that the meaning of the law is different in when the judge is implementing that, and judge is confused that this meaning does not apply here. What should I do? Then that is the judge's job to make an interpretation. Sometimes that legislation may have also loophole. Loophole means gaps. It's not very clear. Words can have more than one meaning, and sometimes there are printing and drafting errors, because of which when the document is in front of the judge, it gives different meanings. Now, what is the assistance? There are certain presumptions that we need to understand when the judges have to make the decisions. We will study the aids to interpretation and then the rules of interpretation. This is the overall uh, outlook of this topic. So number one, these are the presumptions. These are considered only when the law is to be interpreted, which has a dual meaning or is not very clear. Number one, it will be assumed by the judge a statute does not alter existing common law. This means that this is, suppose, statute A, B, C, and there is a sentence in it. This is the sentence, and there is a word in it. Now this word has two meanings, meaning A, suppose say meaning X, and meaning Y. This word has two meanings in that. Now judge has to interpret. The first thing that it will see, that if either of these two has a meaning against an existing common law, for example, X goes against a common law, while Y does not go against, it will not take the X meaning, it will take the Y meaning. So read it again. A statute does not alter existing common law. If a statute is capable of two interpretations, one involving alteration of common law and the other not, the latter interpretation, that one which does not alter the law, that will be taken, that will have more importance. Number two, if a statute deprives a person of property, if the meaning is such, then, for example, nationalization, they are to be compensated for the value automatically. So if the law is interpreted in such a way that a person's house is taken as a decision, then it is automatically assumed that the government will have to pay for that property. A statute does not intend to deprive a person of liberty. If it does so, clear words must be used. This is relevant legislation covering, for example, mental health and immigration and things like that, because there are different liberties, freedom of speech, freedom of expression, etc. So if a statute is worded in such a way that it is taking somebody's liberty, the judge will not take that interpretation. A statute does not have retrospective effect. Retrospective, this word we will be using quite some times in our course. It means backdated. to a date earlier than it becoming a law. So, for example, the case is going on and the statute is made today. It cannot have effect with a back date. The action was in the back date, the statute is now, it does not have any bearing on the previous date action. A statute does not bind the crown. In certain cases, the crown's potential liability is great, and this is therefore extremely important assumption, meaning that if there is a meaning under which the crown is to be subjected, that will not be applied. A statute generally has effect only in the UK. For international obligation, you have to go to the international law. A statute cannot impose a criminal liability without proof of guilty intention. Many modern statutes rebut this. Okay, a statute cannot impose criminal liability without proof of guilty intention. This means that the prosecution will have to prove first that there was a guilty intention. After that, that statute can be interpreted into a criminal liability. A statute does not repeal other statutes. Again, just like the first one. If in that we said the common law, here we say statute. If there are two interpretations of a point in the statute, one goes against another statute, that will not be taken. That interpretation will be void. Then the judge, from where can it get assistance to interpret these legislations, these statutes? Number one, intrinsic. Number two, extrinsic. Intrinsic means internal to the statute, the book that I said, the internal to its title, its preamble, interpretation sections are already there in the book, in the act, side notes included in the statute documents. Whereas the external means external to the statute, reports of law commission, Hansard, it is an official report of the UK Parliament debate. So you see, when suppose the Companies Act, when it was being developed and when it was being discussed upon, the Parliament, there were debates going on. That debates is not included in the law, but it is documented elsewhere in the Hansard. So when the judge wants to get a deeper view of what the law actually intended, what it actually meant, they can go to study those debates as well, so as to have a background of what was in the minds of the parliamentarians when they were discussing that law. Similarly, green paper, white paper, and draft of law are also important areas from where it can get an idea of what actually law meant when it was being developed. Finally, we have the rules of interpretation. In order to understand these rules, you can have two major distinctions. In one distinction, we have literal rule and its refined form, golden rule. In the other, we have mischievous rule. Mischief rule is narrow, and broader view is that of purposive approach. Refined and borrowed. I'll give you an example here, just distinct description here, and then we will study different cases with the help of which you will be able to understand how it goes. So number one, literal rule, as the name suggests, judges must follow the exact meaning of the writing of the law, no matter how illogical or absurd the interpretation may be. But you see, sometimes, and we will study different cases, sometimes that happens that when the exact meaning is applied, the result is nonsense. Result is very illogical. But it is not the judge's job to implement it as it is. They can interpret. So what they do is then they modify. When they realize that this is going sort of a rubbish, there is no proper result of the case if we implement the wording of the law as it is. So then they modified it. They try to avoid the absurdity or illogical results. Again, we'll study in a while. Mischief rule and its broader aspect is the purposive approach. Mischief rule is the oldest approach. Judges consider what mischief, what specific point the law was trying to prevent. Whereas in a purposive approach, we consider the overall purpose of the law in the context of a certain situation of the law. Now, let us understand these two with the help of these cases. Just a minute, please. Okay. Let's discuss first the literal rule and the golden rule. The literal rule means that the words in the act, whatever act is being interpreted, should be given their literal and grammatical meaning rather than what judge think that they mean. So this was the oldest one, and it actually unburdened the judges that we did not make the law. If it gives us stupid meaning, we cannot change the law. Now, what happened in this case? The first one. In Whiteley versus Chappell, 1868, there was a statute aimed at preventing electoral malpractice, meaning that a person should not impersonate another person and cast a vote. Made it an offense. Wherever there is word offense, this means a criminal charge to impersonate. And now, whenever there is inverted commas, this means that it is the exact phrase or exact wording of the act. Now, this specific phrase was written in the act. Now, focus. A statute aimed at preventing electoral malpractice made it an offense to impersonate any person entitled to vote at an election. This means what is a crime? If you impersonate any person who is entitled to vote, that will be a crime. If a person is not entitled to vote and you impersonate him, that is not a crime. So you see, it was not focusing on impersonation. It was focusing on impersonating a person who is entitled to vote. Law did not say that it is illegal to impersonate and vote. It said that impersonating any person who is entitled to vote. The phrase was there. Okay. The accused, the defendant, was acquitted because he impersonated a dead person. You see, now the defense attorney of that person, of the defendant, says that, you see, the law says that it is illegal to impersonate a person who is entitled to vote. A dead person is not entitled to vote. So if my client has impersonated a dead person, meaning he has stolen his identity, even though it looks like a crime, but because if you go in with a literal meaning, he did not commit any crime because he impersonated a person who is not entitled to vote. So you see, he was a dead person was not clearly entitled to vote. So when you apply the literal rule, the result in this case, he did impersonate. He should have been imprisoned or some penalty should have been there, but it was not because the judge took the literal meaning of the law. Now let's come to the golden rule, which states that the word should given their plain ordinary literal meaning unless this would give rise or manifest absurdity or inconsistency with the rest of the statute. Now, this binds the judges to interpret in a better way, to interpret in such a way that the absurdity of the meaning is not there. It can be avoided. For example, the case of 𝐂𝐶𝐬𝐲 in 1935 saw a son murder his mother. Justice Act. This act would mean that the son would inherit his murdered mother's estate. There was a separate law that said that if a mother is passed away or she is murdered, the son will inherit the property. Now, the judge said that we will apply a golden rule on it, not the literal rule. The court said, applied the golden rule, stating that a murderer should not benefit from their crime and therefore law would not be interpreted literally in this. Which law? Administration of Justice Act. Meaning, even though it said that the son would inherit murdered mother's estate, he will not because he is actually benefiting from his own crime, which should not be allowed. So you see, the law change, the interpretation changed from the literal rule to the golden rule to give a better result for the judges. Number two is the case of mischief rule and the purposive approach. Under the mischief rule, a judge considered, a minute please. Excuse me for that. Okay. Now, under the mischief rule, a judge considered that what mischief was that act was intended to prevent. Where a statute is designed to remedy a weakness in law, the correct interpretation is the one which achieves it. Now, in Crockery versus Carpenter 1950, the court held that a bicycle was a carriage. Again, you see the word carriage is in inverted commas. In the law, the word was written as carriage. And if you have an idea, in UK in those days, earlier days, they had a carriage, a covered box in front of which they had horses attached, 2, 4, or 6 horses attached. You would see in different movies. Though that was the word used for, the carriage word was used for that particular one. For bicycle, the word carriage was never used. So that is the basic idea. The court held that bicycle was a carriage. Why? For the purpose of licensing act. In licensing act, the word carriage was written, but the defendant was riding a bicycle. The defense attorney wanted to take the same plea as in literal rule, that my client was riding a bicycle, he was not riding a carriage. The law states about carriage, but judge looked deeper into it. That by using the word carriage or by making that law, what mischief or what problem law was trying to get away deny, where a defendant was charged with cycling whilst intoxicated. So he was under the influence of alcohol and he was trying to ride a bicycle and he hit somebody. The case was done under this act, licensing act. So the defense attorney said that the act says carriage. My client was riding a bicycle. It does not apply to him. But the judge says that no. The purpose of the act was to prevent people who are in the state of intoxication from operating any form of transport on public roads. So they said that carriage does not take a literal meaning. It means what mischief, what problem the law was trying to avoid is that anybody who's riding a bicycle and he's under the influence of law, he should not ride any form of transport. So that was the rule. Okay. The next is the purposive approach. And again, this is a broader extension uh, of the mischief rule. Under the purposive approach to the statutory interpretation, the words of the statute are interpreted not only in their ordinary literal and grammatical sense, but also with reference to the context and purpose of the legislation. You see, we discussed that when the law is made, there is a whole debate behind it. So for purposive approach, the judge will go to those debates, to those discussions. What was the aim of that, main aim of that law, which is usually the uh, main purpose. Why was the law being made in the first place? Okay. So the idea case is Gardiner versus Sevenoaks, RDC 1950. The facts of the case were the purpose of an act was to provide the safe storage of film wherever it might be stored on the premises. So again, the word premises was used. The claimant argued that the premises did not include a cave, and so the act had no application to the case. Decision was the purpose of the act was to protect the safety of person working in all places where the film was stored. If the film was stored in a cave, the premises would be include the word cave, include the cave. Means that if it is a, suppose you are filming in a jungle and a hut is created and the films are stored over there, this means that word premises will be applied over there. Premises would not necessarily mean a particular building in which the films are to be stored, or you say that that is premises and that would be. So the overall purpose of the law is to be considered. The key to purposive approach is that the judges construes the statute in such a way as to be the consistent with the purpose of the statute as they understand it, even if the wording of the statute could be applied literally without leading to manifest absurdity. Okay. We have a little bit of a reading of the Human Rights Act. I'll just give you about 2 to 3 minutes. Just generally skim through these and then I'll explain it to you. General skimming. Okay. So, Human Rights Act, um, moral claims, including cultural, economic, political, such as the right to life, liberty, dignity, education, equality before the law, the right of association, belief, free speech. Generally, when we see these all liberties, these are included in the Human Rights Act. What is the purpose? Human Rights Act 1998 incorporates the European Convention for the Protection of Human Rights and Fundamental Freedoms into UK domestic law. What is the convention law? Convention law means the convention and decisions of the European Court of Human Rights. How does it affect? This is the main idea that you need to remember. How does it affect judicial interpretation? UK courts must take convention law into account when deciding questions that are arisen in connection with the convention right. So, under normal circumstances, the UK laws are sufficient. For example, laws related to property law, contract law, tort law. But if it is something about the human rights, then it has to take into account the Convention of the European Court of Human Rights. Judges will not be bound by previous interpretation of existing legislation where it did not take into account the convention rights. So that is the primary. But in which cases, not all the cases, only the cases related to the human rights. The European Court of Human Rights is free to depart from its own previous decisions. That is the main idea here. What is, and this is the most important from the exam point of view. What if a legislation in the UK is incompatible with the convention? Any existing legislation must be interpreted so it is compatible with the under the rights of the convention if there is an existing one. If the court feels that legislation is incompatible with the convention, it cannot interpret it in such a way to make it compatible. It may make a declaration of incompatibility. However, the declaration does not make the legislation invalid. It is left to the parliament to remedy the situation. So you see, this is the main idea from this, which is tested. The judges cannot change the existing UK law. They have to either make an interpretation which is compatible with the European Court conventions. Otherwise, it will say that it is not cannot be made compatible and refer it to the parliament, and the parliament can make it invalid or make changes to it. However, the courts do have the power to declare delegated legislation to be invalid. So you see, the act of parliament cannot be made invalid, whereas the delegation legislation can be whenever they are not compatible with the Human Rights Act. With this, we are through with the basics of law, and we will have a comprehensive practice on the exam on the MCQs. I'll give you about 3 and 5, 8 minutes to freshen up, and then I'll show you the questions and I'll be expecting answers from you, A, B, C, or D, or whatever the case may be. So about now it's 7 minutes break, and then we will continue with our exam practice. Okay, now I'll be showing you some questions. You will have to read the question, select the appropriate answer, and write with ABC. Or usually ABC is not given, but you can get an idea. For example, this is the first set of questions here. 1, 2, 3, 4, 5, and 6. You can, for example, the first question is, which of the following is a prosecutor in a criminal case? So the answer is the state. So you can write in the chat section 1A. Similarly, attempt all of these questions, and then if you have any queries or if the answers are not correct, I'll explain these to you. If you have done it correctly, I will go ahead with it. Please attempt these. Hello, guys. Expecting answers. These are 1 mark questions, so it will take about 1 minute or so to write the correct answer, please. It is very important that we practice these questions. Okay, one student has said that it's first day. It's okay, Ritesh. The recording of the previous lecture is also uploaded over there on the portal. You can check that out. And if you have gone through today's lecture, then later questions will come and see how many can you attempt. It's okay, no problem. Okay. So the first question I told you, which of the following describes the standard of proof in a civil law case? In civil law, we say it is the balance of probability. Beyond reasonable doubt is in the criminal cases, and beyond all probability is not at all in any type of case. Next, which of the following is a remedy available under civil law? In civil law, it is only damages. Imprisonment and fine is in the criminal cases. Then, all criminal law cases begin in which of the following courts? That will be the magistrate court. King's bench. आप करो मैं आता हूँ. The King's Bench and family, they are concerned which court? These are of the High Court's division. Which of the following statements concerning cases brought before magistrate court is correct? Okay. The case is decided by magistrate rather than a jury. Means this is a summary offenses. Usually jury is required in the higher crown court or the um, um, county court. Okay. Again, next questions 1, 2, 3, 4, and 5. Try to write one and don't press enter. Write in one single message so that I can compare your answers. Okay. Which of the following would only be heard at magistrate's case? A summary offense. Just a minute. Wait. So a summary offense, just like in the previous question, summary offense is that in which jury is not required. Which type of law is concerned with the function and operation of local authorities? That would be public law. Okay, beta. Which of the following? Okay, need to check your answers along as well. Okay. Which of the following terms are associated with criminal law rather than civil law? That will be punishment and public law. Compensation and claimant, these are in the civil law. Remember that under normal circumstances and 99% of the cases in your course, punishment is and fines and imprisonment are only attached with the criminal law, not the civil law. Which of the following are the parties involved in the civil law cases? That will be the defendant and the claimant. Accused and prosecution are in the criminal cases. And in civil system, cases are allocated to one of the tracks, which is not a track. Okay, 5B. Sorry, B. Yes, medium is not a track. Okay, please attempt these. In the criminal law system, an immediate appeal regarding decision by magistrate court could be heard by which of the following courts? Okay, that will be the Crown Court immediately above that. Which of the following courts has civil jurisdiction? Okay, County Court. Chancery division is the involving which of the matters? That will be trust and mortgages. 3B, okay. Right, good. Which of the following are types of offenses heard by magistrate court? Summary and tribal, either way. Very good. This I will explain. You do this. Rather, I should do it right here. Okay. These three terms that you need to remember: obiter dicta, per incurium, and ratio decidendi. Ratio decidendi means reason for decision, or the legal reason for decision. Whenever judge has to write a decision, he takes it from a precedent or a common law or a statute. He will have to write what is the legal reason for the decision that I'm making, and that legal reason is called ratio decidendi. Obiter dicta is a suggestion. Sometimes the judge takes a decision but says that had that happened, my decision would have been this. That is not a binding portion. Ratio decidendi becomes the binding portion for the future cases, or the precedent for the future cases. Obiter dicta is just the suggestion of the judge or the court that if certain situation happened, this would have been the decision. Per incurium is means without, with, or with no regard to law, meaning without considering the law. Okay, now you can attempt these questions. Okay. So the first one, yes, ratio decidendi. The second one would be reversing. Which of the four types in where court higher hierarchy overturns the verdict of the lower court? Overturn means reverses, so that is reversing. Which of the following statement legislation is correct? May modify. Okay. You see, legislation may not overrule, modify, it can. Legislation may prevent a subsequent parliament from, it cannot prevent a subsequent parliament to change the law. Any law that is made can be changed. Which of the following types of legislation affects specific individual or groups? That will be private law. Good. Which of the rules of interest sets that words in the state should be given their plain ordinary meaning unless this would give rise to a manifest absurdity? That will be golden rule. Good. Your responses are quite good. Well done. Okay. Which of the following is an intrinsic? Intrinsic means that is contained within the document book. That will be the long title. Which of the following is a final appeal court for human rights issues? That will be European Court of Human Rights. For all other issues, it will be the Supreme Court. For all other issues, it will be the Supreme Court. Remember that. For issues related to the human rights, they can appeal into the European Court of Human Rights. The decision of which of the following court is binding on the appeal court of appeals? That would be Court of Appeals itself. Very good. Because the Supreme Court is not given in the list. Which of the following statements concerning principle of binding precedent is not correct? You have to focus more on these questions which ask about least likely or not. Okay, that would be mistakes by judges are eliminated. So if there is a binding precedent, it does not necessarily mean that the judges cannot make mistakes. They can still make it. Which of the following stages are a bill passes through before legislation? That will be report stage and committee stage. Very good job. Some statutory interpretation require resolution of parliament to come into effect, but others must be late. That is for 40 days. Which rule or approach statute will consider the following to achieve? Okay, that will be purposive approach. Okay, which rule, which the legislation is trying to achieve, that shows the purpose. Presumptions of statutory interpretation provide judges with the rules to use when interpreting legislation. That would be C. Okay. Okay. See, statute does not bind the crown. You have written 3 as C, but the presumption says that statute does not bind the crown. Okay. Which of the following is an extrinsic trait to statutory? That will be the answer. Okay, so with that, our today's topic comes to an end. We have covered the basics and backgrounds of UK legal system. From next session, we will be starting with the contract law, which is one major chunk of our course. If you have any questions or queries, you may please ask. Otherwise, today's session has ended from my side. You.